Can directors face jail time following unfair dismissal disputes? And what are the consequences of non-compliance with labour laws? This is stuff employers should know.
Welcome to Stuff Employers Should Know, proudly brought to you by LabourNet, management's ultimate HR solution.
Hey, and welcome to the podcast. I'm Barry Gordon-Davis, litigation manager for LabourNet, and today I'm joined by Audrey Lowe, who is the National Labour Law Support Manager for LabourNet. Welcome, Audrey.
Thank you very much, Barry.
Just to reiterate the purpose of the show, as Stuff Employers Should Know, we take bite-sized chunks of broad topics and try and go with a précis approach, not a long-winded session or series, talking about really the nitty-gritties of what we need to know. And what happened or put it this way, the idea for this particular show, I wrote an article during the week relating to a case that came out of the Labour Court, where it was for contempt proceedings and a response. Well, in this particular instance, it was the respondents, the employer in this particular matter, that was found to be in contempt of court. And interestingly, in the outcome of those that particular judgment was the fact that they then also ordered that if they failed to comply with the award or the court order, that it may possibly result in a period of incarceration. So that's on the tip of our tongue with regards to the fact that, after an unfair dismissal dispute, matter goes through the different proceedings, and should an employer then fail to act on, let's say, an award or even then a court order, what the potential repercussions are. We then also saw in the media this week where there were raids happening on various establishments, particularly the restaurant industry, where there were arrests being made. So under those circumstances, I thought it was quite pertinent that we then discuss the consequences of non-compliance, specifically in the fields of employment or the labour law umbrella. So that's why I've asked Audrey to join me, and maybe between the two of us, we can shed some light on the various topics. So let's start from the beginning. When it comes to, let's say, unfair labour practice or an unfair dismissal dispute in particular, that we'll talk about other types of compliance later on. And we all know that an employee has the right to go and refer a dispute to the CCMA or the relevant bargaining council in their particular industry. What jurisdiction do these forums have over potential awards or, let's say, finding an employer wanting when it comes to unfair dismissal or an unfair labour practice?
Yeah, Barry. So as we know, employees have learned with time that the CCMA is there to help them whenever they feel that they've been treated unfairly. So a lot more cases are being referred to the CCMA these days than they used to in the past. And for the most part, it's for compliance with either the Basic Conditions of Employment Act or the Labour Relations Act. Basic Conditions of Employment Act regulating specific things that the employer is supposed to comply with. Where they don't comply with some of these things, it could be considered an unfair labour practice. And of course, where employees are dismissed in contravention of the Labour Relations Act, those would then be your unfair dismissals, and in some cases, your automatically unfair dismissals, which the CCMA would hear. In some cases, arbitration awards would be issued. So we first try to conciliate and try to get to the bottom of the matter and reach an agreement between the parties to settle amicably. If that fails, it would then either go to the CCMA again for arbitration, where an award is then issued, or in certain instances, it would have to go on to the Labour Court, where adjudication would be required for certain cases. But most of the matters would go to arbitration at the CCMA, and that arbitration award is final and binding. And that is something that the employer is then compelled to comply with. Otherwise, they get into trouble, as was the case in the matters that you've spoken about already.
Now, we know that the potential, you said, reinstatement, reemployment compensation, the CCMA has jurisdiction of 12 months, and Labour Court, you spoke about automatically unfair dismissals. Matter going to the Labour Court would result in potentially a compensatory amount equivalent to 24 months compensation. That, when you compound it with with re-employment, reinstatement can be quite profound on employers. So specifically the labor court, I mean, obviously that's a court, and employers, I don't think that there's an employer that wouldn't take a order of the court seriously. But in terms of the CCMA and bargaining councils, there are a lot of employers out there that, let's say, for example, don't take the award seriously, or there's a lot of times instances where they get a default award. Let's say through the process, the CCMA issues a default award because the employer failed to appear at the CCMA, be it where there was intentionally a willful, I'm not going to go and attend these proceedings, I don't acknowledge them, or under other circumstances where the employer just didn't know about it. Let's say they weren't notified correctly and the like. Now, without delving into how we get out of those particular situations when it comes to the employer's rights and employee rights in terms of that, what I want to emphasize is that where there's this nonchalant attitude in certain circumstances to bargaining council awards or CCMA awards, what's the process then that happens from there where a employer is faced with let's say, an award from the CCMA?
Okay, so employers ignore awards from the CCMA or the bargaining council at their own peril. As I said, an arbitration award is final and binding on the part of the employer. It's not something that they get to ignore. Where they then fail to comply with whatever it is that the CCMA or the council has set down, what the employee can do from their side is to approach the CCMA again and have that award certified by the director of the CCMA. And by having the award certified, it then bears the same force as an order of the court. And once
so it becomes akin to an order, it's then in the same light as a labour court order.
Of the court, and a sheriff then has the authority to go and execute that order against the employer.
So, and I know we've done a podcast previously about what happens where there is, let's say, the sheriff arriving at one's door. But for the purposes of, let's say, the process of the sheriff in order to execute the award is unsuccessful, or specifically when it comes to, let's say, awards that have now been made an order of the court that are not sounding in money, but let's say, for example, requiring an act on the employer, such as reinstatement or reemployment. The process thereon is they then go and apply to the labour court.
They go to the labour court, and where the employer then fails to comply after having been told to do so by the sheriff, we would then have to institute contempt of court proceedings against the employer. And that's where things get a lot more serious in a hurry if the employer does not comply with that award.
And yes, so the employer would then go and apply for contempt proceedings at the labour court. And it's not as simple as that, where the labour court will say, okay, well, you haven't adhered to it, you're in contempt of court. How does the labour court look at, and what does the labour court do in order to, and obviously I know that it's a lot more broad, but in short, what are the steps that they follow to determine whether an employer actually, in fact, is in contempt of court or not? Because we know that sometimes employers may try, or they attempted to and they failed, but what needs to be demonstrated in the labour court for an employer to be found in contempt?
So basically, when an application for contempt of court order is put in, what the court is going to look at to determine if the party is actually in contempt is first and foremost that party was aware of the award. So they were served with the award, they're aware that an award has been issued against them, that they are supposed to comply with. So specific things that the court is going to look at to determine whether a party is in fact in contempt of court is first and foremost that there was an order against them and that the party was aware of the order against them that they were supposed to comply with. They would then look at whether that party willfully failed to comply with that award. So I know what I'm supposed to do. I decided I'm not going to do it for whatever reason. And then the final hurdle to cross, and this is probably the most difficult part to prove, is to determine whether that failure to comply with the award was mala fide. So specifically, whether there was no justifiable reason on the part of the employer for not complying with that award. And the onus of proof, or the burden of proof that we use to determine whether there was mala fides, is going to depend on the possible outcome of that award. So in a situation where we're looking at possible incarceration, these elements would have to be proven beyond reasonable doubt. Whereas if we're looking at a civil contempt claim, beyond reasonable doubt,
so then it would not be beyond reasonable doubt. Then it's on a balance of probability.
Balance of probability would be the measure that we use to determine whether or not the person was acting in mala fides.
So we are obviously very, very familiar with the balance of probabilities element, specifically in most aspects of labor law. This would be one of those elements where beyond reasonable doubt is required.
That's it.
Now, we know that's obviously the runaway train process of having a award certified and then executed, and extreme circumstances then possibly resulting in a contempt proceedings. I spoke about the fact that there might be a default award where it wasn't necessarily the employer that was willingly not adhere to the award, or in, let's say, for example, where there is an award and the employer then intends on taking it on review. It was obviously made clear in many cases that the attempt by an employer to, let's say, review or even go in appeal processes is not grounds to then stay the award. And it was proven that if an employer has an award that is technically looming over them, what is the processes that they would need to demonstrate in order to then go and stay the award so that contempt proceedings wouldn't be successful against them?
Okay. So certain steps that the employer would have to take for the award to not be enforceable in the interim, because as we said, it's final and binding, it's immediately executable unless the employer takes steps to try and stay this award. So they can do this in various ways. The first would be to furnish security on taking the matter on review. So in the case of something like a reinstatement or a reemployment, your security would be equal to 24 months of the employee's remuneration that we are taking the award in review of. If it's in terms of a compensation award, it would have to be equal to the compensation that has been granted. So that's step number one. Once I have furnished the security, the award is automatically stayed. That's the easiest way to do this. If we're not going to furnish security, especially in certain circumstances where we're dealing with awards involving a very large number of employees, where the amount of security that we would have to furnish could be exorbitant, the employer can still approach the Labour Court and apply for the stay of the award. So irrespective of whether or not security has been furnished, the Labour Court still has the authority to stay the award if sufficient grounds are shown to motivate for it.
So we've spoken about, when it comes to, your day-to-day labor practices and stuff and the consequences thereof. But then the moment let's say a person becomes an employer, or the moment a juristic person becomes an employer, there's certain compliance that is required from them. We know that it's made, other than other statutes, the most predominant one that we know prescribes what is required in terms of compliance would be the Basic Conditions of Employment Act. Now, when it comes to the Basic Conditions of Employment Act and the adherence and compliance thereof, who is responsible? We've just spoken about the CCMA. Who's responsible for ensuring the compliance of employers when it comes to the BCEA elements?
So predominantly, that's going to be the Department of Employment and Labour. So they have inspectors that they send out to go and do inspections on employers. This can be on a random basis. This can be because they received an anonymous tip from an employee, for example. We saw that happening on TikTok recently.
Yes.
It can also be because one of the unions might have intervened and flagged that there was an issue with an employer and reported it to the Department of Employment and Labour. So they would then send an inspector in to go and have a look at what the situation is with that employer and to see whether they are fully compliant with the Basic Conditions of Employment Act.
And in addition to that, we've also seen where they have their own, it's in their prerogative to go and do rounds and particularly sometimes they'll choose a particular industry and go and do the rounds with it. It happens, but not as common, where there would be just a labour inspector arriving on site. I suppose in order to see the true reflection of the employer, that would probably be the best way. However, sometimes it's a lot more courteous than that, where they would issue the employer with a notice of intent to inspect and list all the various items that they are going to be looking at, to give the employer an opportunity to have them on hand, have them presented. They still choose random samples from it, obviously to ensure that the employer doesn't then go and put their best foot forward, but they go and put through the generalist approach as to ensuring compliance. But it does happen quite often, and I know we get quite a lot of calls where a employer has a so-called labor inspector just arriving, and they are, in typical employer fashion or employment fashion, make an appointment like everybody else, and intends on either, barring them from entry or chasing them away. What happens under those circumstances?
Okay, so this is a very important thing that employers need to be aware of, is that a labor inspector does not need to have an appointment or a booking or prior notice to be able to come in and inspect the premises. Okay, so in terms of the Basic Conditions of Employment Act, they can pitch up whenever is convenient for them, bearing in mind, of course, that it must be within working hours, and to come and conduct the inspection. And the reason for this, obviously, is we don't want to give the employer time to hide things if we know there's an issue. So if that happens, if we do have a random person who pitches in the lobby and says, listen, I'm from the Department of Employment and Labour, I'm here to do an inspection, there is a need for employers to confirm that this person is, in fact, an inspector. Because it's not beyond some of the unions, some of the political parties, it might even be professional rivals, to come in and try and gain access to certain information that they can use against the employer. So what the employer can do in that situation is they can request this person to furnish them with a signed certificate from the Department of Employment and Labour. This would be signed by the Minister of Employment and Labour, that certifies that this person is in fact a labour inspector. And the certificate would also set out what this person is empowered to come and inspect. So it would tell the employer in terms of what pieces of legislation this person is empowered to inspect, and what kind of things they can come and look at. Once the person is able to furnish us with the certificate, you will have to let this person in. They've got the right to look at documents. They can request to see your financial statements. They can look at time and attendance registers. They can also interview your employees, who's obviously going to give them the down low on what exactly has been happening in that particular workplace. And if we don't do this, if we don't, upon having established that this person is genuinely an inspector, chase you away or bar you from entering, that has other consequences that we're then going to have to deal with.
So in addition to them obviously issuing a compliance order, if they find a shortfall on any of the elements that an employer is required to be compliant on, as you said, the barring of an inspector or interfering with the inspector's work itself would be seen as non-compliance, and they can actually issue a non-compliance certificate ordering compliance, specifically on the grounds of not allowing them access or not allowing them access to the workplace. So where there is a non-compliance on that ground or any of the other grounds, it generally will then provide employers with a period of time to demonstrate to the Department of Employment and Labour that they have now in fact complied. Or we know under certain circumstances where they find non-compliance, they might already at that point in time issue a fine. We know in terms of the National Minimum Wage Act, it would be a fine equivalent to the difference between the two amounts, or double the two amounts, depending on which one is higher. And under those circumstances, let's say, for example, where there is a compliance order, there is a time that is given and the employer fails to act on it during that time, the same process would then apply, where that would then be referred as a dispute to the CCMA. The CCMA turns it into an award. The award then, as through everything that we've spoken about now, would then go through the exact same proceedings when it comes to contempt. What we saw in the media, particularly this week, where there were raids, and I mean, I spoke about this initial case earlier, I didn't obviously name the case because I wanted this to be broad in terms of what can happen with any employers.
I did see certain restaurants in Pretoria and Sandton in particular have been getting some attention from the media after they received a lot of attention from the Department of Employment and Labour, along with the Hawks and SAPS altogether, who came to check on non-compliances in terms of the Basic Conditions of Employment Act, but also as far as the Immigration Act goes.
Yes.
So a lot of employers who've been caught with illegal foreigners working in their employ, people who don't have the correct documentation, those people obviously liable to be arrested and possibly deported. But where the employer has failed to ensure that their employees are in fact legitimately working in South Africa, where they haven't ensured that these people are documented, then the employers themselves are also liable to possibly be arrested and pay fines.
And hence that's what we saw playing out in the media. So I suppose the conclusion of today's show is that, yes, the consequences of non-compliance in, let's say, labour practice, as well as just establishing the business with regards to the general compliance of labour laws, is extremely paramount. And I think that employers become quite nonchalant when we don't necessarily see these things playing out in the media, but it always gives us a serious wake-up call when we see what happens, when we actually see the consequences of non-compliance playing out, be it in the public sphere, and we all see the potential consequences that can have on a company's good name, just being associated with these things. And I think it's all more paramount that we then ensure that as employers, we are aware of what is required in our business, and that we then make every step to ensure the compliance thereof. Now, I know that there might be viewers now viewers, but mostly listeners to this podcast that might be wondering the very same. And that's where you can always get in touch with a company like LabourNet, where they would come and do obligation-free assessments of one's business and go and outline the areas of their business that are, let's say, posing a potential risk to everything that we've spoken about now. Audrey and myself have spoken about the labour law side of things, but there are occupational health and safety issues, there is employment equity issues, and all the non-compliance and all those various components have pretty much the same, or in certain circumstances, even more dire consequences. So it's paramount that you reach out to companies like LabourNet and ensure that you are compliant in that regard. So thank you, Audrey. Thank you for your time today. And thank you very much.
Thank you very much, Barry.
So that's it for this episode of Stuff Employers Should Know. If you want to get in touch with us and, let's say, propose a topic that you would want us to discuss, you can fire off an email to sesk@labournet.com. So from myself, BGD, Audrey Lowe, and Yassa in the background, till the next episode, cheers.
Stuff Employers Should Know was proudly brought to you by LabourNet, management's ultimate HR solution. For more episodes from Stuff Employers Should Know, go to Apple Podcasts, Google Podcasts, or wherever you play your favorite shows. Case law or statutes referenced in the podcast are current at the time of recording.